Good afternoon. My name is Jason Colleen, and welcome to the Department of Cannabis Regulations California Environmental Quality Act and Notice of Exemption webinar. For those that don't know, the California Environmental Quality Act requires California public agencies to consider the potential impacts from new projects and businesses. All public agencies, including the Department of Cannabis Regulation, must comply with CEQA. And DCR does that by verifying that all licensed cannabis businesses and applicants meet the requirements under CEQA. Cannabis businesses that have been doing business under the City of Los Angeles's temporary approval program and the state's Department of Cannabis Control's provisional license program are required to convert to annual licenses in calendar year 2025. The annual licensing process is a more permanent license and requires the completion of an environmental review. DCR's role in this process is we serve as the lead agency for the City of Los Angeles for all commercial cannabis businesses. As the lead agency, DCR must first determine that an application is complete and if that business would create a new environmental impact. For the records that we've reviewed to date, most businesses have qualified for an exemption from CEQA. If a business does not qualify for an exemption, then a more robust environmental review must be completed. In order to transition from the city's temporary approval and state provisional processes to an annual license, a business must be issued a local annual license and meet all of the environmental requirements. The environmental requirements are adopted as part of the city's process to determine whether or not an applicant will be issued an annual license. For retail storefront activities, of course, those go through the Cannabis Regulation Commission, and DCR's environmental review are included with the staff report and findings. For non-retail activities, they're also included in DCR's staff report and findings, but those reports come to the Assistant Executive Director over licensing for review and approval. Once a determination has been made to grant an annual license, then and only then can DCR file the necessary environmental documents with other government agencies. The types of documents that cannabis businesses must supply to DCR include the LIC 4013 form, and DCR pulls the Department of City Planning's parcel report from the Zoning Information Map Access System. That, in conjunction with all of the other documents that are uploaded as part of the application process, serve as the basis for DCR to do its environmental review. If we determine that the project qualifies for a notice of exemption, we have to submit that to the Los Angeles County Register Recorder. And then once it's been filed with the county recorder, then DCR has the ability to submit it to the California Governor's Office of Planning and Research, or OPR. On the next couple of slides, we have samples of the documents. So sample 1 is the template for the staff report. Sample 2 is the project-specific information form, also known as LIC 4013-form. And then sample 3 is a parcel report from the Zoning Information Map Access System. These 3 documents are submitted in conjunction with the actual environmental filings. Once we've made a determination to issue an annual license, staff prepare a notice of exemption to be filed with the office of the city, with the county clerk. The county clerk's office will post this on their website and give us a stamped copy back. That stamped copy then gets scanned and put behind the Office of Planning and Research notice of exemption form along with all of the other documents that are part of the environmental review package, which are samples 1, 2, and 3. And then it gets filed through the state's CEQA website. When DCR does its filing through CEQA, we also put a copy of the filed notice of exemption in a Dropbox for the Department of Cannabis Control so that the state agency knows that it's already been uploaded. The DCR team is working directly with the Department of Cannabis Control, and we do share lists with them, which indicate which businesses have been issued a notice of exemption. And to the extent possible, we try to provide information that correlates the DCR core record number with the corresponding state license numbers. If a business is determined not to be exempt from CEQA, then DCR must evaluate whether or not the business has a possible significant environmental effect under law. If the business is not exempt and there's any possible significant effect, DCR must prepare an initial study to further determine if the project could have significant environmental effects. That, of course, will require the payment of additional fees to begin that study. After the initial study is completed, DCR would prepare either a negative declaration for projects that are determined to have no significant impact, a mitigating negative declaration if the project has impacts that can be mitigated, or an environmental impact report for projects that have significant environmental impacts. DCR's progress and timeline. So beginning in 2024 and through today, 289 annual license applications for the Type 10 retail storefront activity have been approved by the Cannabis Regulation Commission. DCR has also processed any corresponding non-retail activity records for the existing medical marijuana dispensaries that had an LAC record at the same time. And those environmental findings have been filed with the county clerk. As we get those filings back from the county clerk on a rolling basis, we're uploading them to the CEQA website. DCR prioritized processing the Type 10 applications first because they do have to go through a community meeting and public hearing process, which take months. So we wanted to make sure that we prioritize those folks. In December, we began processing the non-retail records that did not have any type of retail activity. The commission will continue to consider the Type 10 applications on a monthly basis. The first Thursday of each month is dedicated to new cases, and then the second meeting of the month will be dedicated to presentations and any continuations. From 2024 through today, 140 non-retail annual license applications have been processed, and those have been submitted to the county clerk. DCR is continuing to process these records on a rolling basis in the order of the DCC provisional license expiration date. Our consultants currently have an additional 120 cases that they're working on that we expect to be delivered in the next 4 to 6 weeks. And DCR staff are also processing records in parallel with those to try to get these done as quickly as possible. Our goal is to try to file all of the notices of exemption for folks that have an existing provisional license before the end of March. Of course, folks that do not qualify for an exemption will have to go through the initial study, and we would begin invoicing folks for those initial study fees in April. As I mentioned, our goal is to process any notice of exemption for City of LA temporary license holders that have a state provisional license by the end of March. We're utilizing a bench of environmental consultants to assist us in making these determinations. Every record in our pipeline will get processed, provided the corresponding fees are paid. You will need to pay any outstanding invoices in order to have the record deemed complete and get this environmental analysis. For folks that do not have a state provisional license, we plan to begin invoicing folks en masse in April. If you need to file your notice of exemption or environmental document with the state prior to that, you can reach out to your DCR analyst and request an invoice and pay those environmental fees. And then once the fees are paid, we will route your case to an environmental consultant so they can prepare your environmental analysis. So next steps, once DCR has made the CEQA determination, we email the licensee a notice of complete application. We file the notice of exemption with the Los Angeles County Register Recorder, County Clerk. The county will stamp and file the NOE, and they mail a copy of the stamped NOE back to DCR. Once we receive the stamped and filed copy, we upload the entire package, including both the staff report, which is samples 1, 2, and 3, the copy of the county clerk NOE, which is sample 4, and then the cover page is the OPR NOE, which is sample 5. And those are filed electronically through the Office of Public Planning and Research website, which is also the state clearinghouse via the CEQA Net website. We also provide that package directly to the Department of Cannabis Control as soon as our posting has been made live in CEQAnet. And getting the live posting through CEQAnet to date has satisfied the DCC's requirement for final CEQA documentation. And again, here's an image of sample 4, which is the filing that goes to the county clerk, and sample 5, which is the filing that gets uploaded to CEQAnet. The state is looking for sample 5 to be uploaded to CEQAnet with the supporting documentations in order to determine the environmental review complete. DCR does notify the Department of Cannabis Control after our electronic posting. However, individual applicants and licensees can notify the DCC and your DCC analyst directly. You can email them at environmentalreview@cannabis.ca.gov. And then for folks, you'll have your unique DCC analyst email address, and you can email a copy directly to them as well. Once DCC receives the NOE, their team is able to continue the review of your annual license record or renewal, and then transition your case over to annual licensure. You can check for your notice of exemption directly through the CEQAnet website. On the current slide, you can narrow, we've got some search parameters so that you can narrow the database search to more quickly locate your document. You can look at the end range, which would be the current date. Document type would be a notice of exemption. The lead public agency would be the City of Los Angeles. And then you would press Get Results. And then under Title, look for your DCR core record number. And that concludes the formal presentation. So with that, I would like to hop over to questions.
Good afternoon to everyone. Our first question comes from KDP. For existing medical marijuana dispensaries who had an annual license hearing in October of last year, when will DCR send the notice of exemption and Secretary of State be published on CEQAnet?
So any of the cases that were approved by the commission October 2024 should already be up on the CEQAnet website. I have the slide up for how to check for the notice of exemption via CEQAnet. And if you're unable to find your filing, please reach out to your DCR analyst.
Our next question, also from KDP. What advice do you have for temporary applicants, licensees, who continue to be contacted by DCC with a request for their CEQA?
It's going to determine the content of the email should determine how you move forward. Senior management with the Department of Cannabis Regulation is meeting with senior, management over at the Department of Cannabis Control every Monday. We go through that aging report that shows the status of the provisional licenses with the state. Currently, we're in the process of getting notices of exemption for March, April, and May filed. So we're ahead of the game in terms of the provisional license deadlines at this point. The DCC analyst, of course, has the ability to discuss the status of your case with more senior staff. They, again, we are working directly with them. We've provided them with anticipated processing timelines. So your analyst or their manager should be aware of where your case is in DCR's pipeline. If that's not sufficient, then it is best to reach out to your DCR analyst, so that can get routed up through our management chain. And then our senior manager who meets with DCC can bring up that specific case during their weekly meeting.
Next question from Robert V. How do I know if I qualify for an exemption?
DCR would let you know after we finish processing your LIC Form 4013, reviewing the parcel report, and then the other business premises and site plan documentation that we have on file. If you qualify for an exemption, then DCR will go ahead and include that recommendation and finding in the staff report. And then we file the notice of exemption on the applicant's behalf with the county clerk and the Office of Public Research, OPR.
Kevin J. asks, how do I know if I am CEQA exempt with others in the building that have passed CEQA? Am I exempt?
The determination that your project is exempt can only be made as part of the determination to issue an annual license. I can't say for certain that your project would be exempt if others in your building were exempt, but there is a strong likelihood that the activity coupled with the underlying business premises, site plan, etc., may qualify for an exemption.
Question from a few individuals, Veshay T, Paul B, and Ebony A. When will non-retail applicants receive their CEQA exemptions? Will we be notified once they are filed with the county recorder?
So the non-retail applications are processed on a rolling basis based on the expiration of the provisional license. The Department of Cannabis Control provided DCR with the local jurisdiction assistance grant, and that grant is being used to waive the environmental related fees for businesses that hold a state provisional. Those monies can only be used for folks that have a state provisional. We've been processing these records on a rolling basis. The grant funds must be utilized by March 31st. So we are trying to get everybody who has a state provisional process before March 31st to take advantage of the maximum amount of grant dollars we can. When we issue a notice of complete application, that is an indication to you as an applicant that DCR has completed its environmental review. We don't notify folks once the NOEs are filed with the county. We do notify folks on a rolling basis once the files have been uploaded to CEQA.net. At some point in the future, we anticipate publishing information on the website that will include links to the state clearinghouse numbers, which are the numbers assigned when a file is uploaded to CEQA.net. That functionality should be online sometime early summer. If you do have a question of whether or not we've issued a notice of exemption or you would like a copy, please reach out to your DCR analyst. And if we've already filed a copy, we can provide you with a link to the CEQA posting via email.
Question from Avash AT. I currently have an applicant that's been waiting for CEQA exemption. DCC has now abandoned the application due to a lack of supporting CEQA documents. My question is, can you contact DCC on our behalf and request for them to reinstate our application?
This is an issue that can be escalated to senior management and brought up during the weekly meeting with DCC. Again, folks are meeting to talk about the aging reports. And if an applicant has paid their fees and their CEQA review is in the pipeline, we can confirm that for the state and give them an anticipated completion date. In the past, they've used that information to reinstate applications, but because they are a different agency and they don't report to DCR, I can't guarantee that they wouldn't reinstate the application, but we can definitely make the request.
Next question from Kelly M. Should we hire a third party to handle CEQA, or is it something that can be done fairly easily? When does CEQA have to be completed?
So you can't hire an independent third party to put together your CEQA documents. DCR still has to do the review, and we rely on our contractors to do that review. So if you hire a third party to do the review, you're still going to have to pay the corresponding DCR fees for the DCR's consultants to do the review as well. Again, if you have a state provisional, we're putting you in the pipeline to have our consultants process your environmental analysis based on the expiration date of your state provisional. If you do not have a state provisional and you would like for us to refer your case to a consultant, you can ask your DCR analyst to issue an invoice for the corresponding environmental analysis fees. Otherwise, we will begin issuing invoices for folks that don't have a state provisional in April of this year, and then the fees will be due based on the due date on the invoice. The environmental review is handled again by a consultant. I would assume that it's fairly easy for them to do the analysis because they are professionals. Generally, our batches are turned around in 4 to 6 weeks, and we do send batches out to each of the consultants on a regular basis. Your CEQA, aka environmental analysis, has to be complete in order for us to determine that you qualify for a notice of complete application and that DCR can actually make a recommendation to issue an annual license. So we do need that environmental review to be complete to deem the application complete, and then in order to make a recommendation to issue the annual license.
Question from Brandon C. Can one get priority for CEQA determinations?
Again, a priority for the environmental review is based on the expiration of the provisional license. And for folks that do not have a provisional license, priority is granted to folks that have paid the corresponding environmental review fees.
A follow-up from Brandon C. If the city is unable to provide CEQA determination prior to DCC license renewal, what will happen, and will the city be able to reach out to the state on our behalf?
Just reiterating the point that, DCC and DCR meet on a weekly basis. We go through those aging reports where we walk through what's in our pipeline, what's been uploaded through CEQAnet, what's pending with our county clerk, and, it directly ties into license renewals and the conversion of annual license applications. So if you have a specific case that needs to be raised, it can be raised as part of those weekly meetings. And if there is an issue or, your license renewal may not be processed before the expiration date of your provisional, we can reach out to the state on your behalf and let them know when we anticipate that information will be uploaded to CEQAnet.
Question from Reza S. I have 3 out of 4 licenses that are being renewed by DCC because they are waiting, or that aren't being renewed because DCC is waiting for CEQA exemptions. What options do we have?
Again, the notice of exemptions are being filed on a rolling basis based on their expiration date on your provisional license. And to my knowledge, all of the NOEs that have been filed to date have been sufficient to allow for applicants to renew and convert over to annual licenses. If you have not been renewed by DCC and you have an expiration date in February, I would recommend reaching out to your DCR analyst to see where your record is in the pipeline. Most likely, your notice of exemption has been filed. It's just either waiting for the stamped copy to come back from the county clerk, or it's in the queue to be processed for the CEQA.net website.
A follow-up from Reza. Who would we contact for CEQA updates?
I would recommend for CEQA updates related to your DCR records, you should reach out to your DCR analyst.
Next question from Paula B. Will submitting any license modifications, such as ownership modification, soon complicate or delay the process of receiving CEQA NOEs from DCR?
It depends. So for businesses that already have temporary approval and corresponding state provisional licenses, those cases are already in the pipeline, and your legal business entity record should have already been deemed active prior to the submission of a modification. For businesses that do not have temporary approval or who do not have active legal business entity records with DCR, an ownership modification could delay the, of course, processing of your legal business entity record. And because that needs to be active before an application can be deemed complete, it would slow down our ability to complete our processing of your application, which then will delay the filing of any environmental documents for that record.
From Nicholas J. Are CEQA exemptions available for micro businesses?
It depends. It's done on a project by project basis. Our existing medical marijuana dispensaries that are engaged in 3 or 4 activities, many of them have already qualified for a notice of exemption. For the city, we define a micro business as a type 9 delivery license and type 11 distribution license. Our definition is different from the state, but given the fact that businesses that have 3 or more activities have qualified for an NOE, a micro business license at the state level may also qualify for a notice of exemption.
From Chauncey B. Why does it take so long to get CEQA approval?
It comes down to funding, resources, the pipeline, the collection of fees, the usage of waiver monies. On a go-forward basis, the CEQA-related fees are going to be included in the annual license application invoice when those applications get submitted to DCR. For existing temporary approval and provisional license holders, the state had awarded DCR the local jurisdiction assistance grant, and those monies were going to be used to waive environmental related fees. That grant term ends March 31st, and folks did not have to have the CEQA documentation to previously renew provisional licenses. Calendar year 2025 is the first year that DCR requires that environmental document to be filed in order to renew and to convert over to an annual license at the state. So given the fact that CEQA wasn't required for temporary approval or state provisional licenses, it's just a matter of processing and using the limited resources to meet the different state deadlines before the deadlines come up.
A question from Kate P. When will notices of exemption be issued for retail businesses?
The notice of exemptions for retail businesses, to the extent that that's the finding for the case, generally get submitted to the county clerk within about 2 weeks of the date the Cannabis Regulation Commission adopts the recommendation to issue an annual license. And then from there, it takes about a week for the county to process the notice of exemption paperwork and mail us a copy of the stamped NOE. And then once we've received the stamped NOEs, our staff put together the packets to upload to the CEQA.net website. So the NOEs are really finalized 4 to 6 weeks after the Cannabis Regulation Commission makes a finding to issue an annual license to the business.
Our next question from Mike S. For applicants who cannot wait their turn in DCR's prioritization list, would DCR be open to allowing the applicant to prepare the Notice of Exemption Appendix E form, the City of LA form, which gets filed to the county clerk, as well as submitting site-specific text, which DCR may use for their determination and approval of commercial cannabis annual license form and findings? Please let me know if you need me to repeat that.
The quick answer is similar to an earlier question. No, you can't hire a third party to do the environmental review and try to bypass the formal city review. The city code does require DCR to do this work. The state sees us as the lead agency for it. So if DCR isn't doing the work either directly or through one of its contractors, that work is not considered valid for the purposes of our application processing or the determinations. So, as I mentioned, we have records in the pipeline that do not have state provisional licenses. Those folks are not eligible for waivers through the LJAC program. Those businesses will be invoiced for the environmental fees. As those environmental fees are paid, their cases will be routed to our bench of environmental consultants. And then, we'll continue the process based on the environmental analysis completed by the consultants. And if we determine that the project is exempt, that finding will be included in the staff report that'll either go to the Cannabis Regulation Commission for consideration or to the Assistant Executive Director over licensing for consideration. But you can't do the analysis yourself. You can't submit the forms to the county or to CEQA.net yourself. The Department of Cannabis Control and DCR won't consider those valid documents.
Question from Marcus. We received a different document that you did not include in your sample titled CEQA Notice of Exemption. This document was sent to DCC from DCR. What is this document?
Without seeing the document, it's hard for me to know exactly what it is. There's a couple of different documents and forms that we created to help facilitate the conversion of records to annual licensure or to, qualify folks for getting a state provisional license. For some folks that were getting requests from their state analyst to get some kind of update or status on where their environmental review was in the process, we had a standalone report titled CEQA Notice of Exemption that folks could provide to their state analyst to notify them that we are going to recommend the a notice of exemption and highlight the fact that the final determination to issue an annual license was pending. That had been used to previously avoid records being abandoned. But it isn't a formal document the state will use for their environmental process. They're only going to accept qualifying docs uploaded through CEQA.
Question from Kate. CEQA search is only showing the latest 100 documents. How do we know if the notice of exemption was issued before that?
I would just recommend emailing DCR licensing or your analyst with the core record number, and we can provide you a link to the state clearinghouse filing through CEQA. I'm guessing it's related to the CRC case that was heard last October. So we can provide a link. We have them.
And this is a follow-up question from Kate. What is the DCR core record number? It does not match a format of DCR temporary or annual license.
What we refer to as the DCR core record number is the unique 6-digit string between the two hyphens. So an application record would start LA-R-24- 6-digit string -A in it. So we're looking for that 6-digit string. That core record number is the same for the LAR records, which go before the commission, and then the LAC or LAS records that go to the assistant executive director over licensing. So when we do our filings, we refer everything to the core number, not the unique record ID, because that analysis is good for both records. Hopefully that helps.
A question from MS. Who are the consultants that DCR is using?
I apologize that I can't tell you offhand. But if you sent us an email, I would be able to respond with the consultant names.
Another question from MS. Why would the environmental review fee be charged multiple times for an applicant that has multiple activities at the same location, especially since multiple NOEs don't get filed?
You would have to, like, the individual asking the question would have to provide me an example, but for records that are under the same core record number, we do not charge multiple environmental fees. We charge the environmental fee one time for the applicant at that location, covering the activities that are all under that core record number. It's tied to an applicant and location, not the number of activities that are applied for at a given location. If somebody qualified for a notice of exemption under one core record number, DCR has a separate fee to do an amendment to that environmental analysis, where additional activities or records could be, reviewed. And then if it still qualifies for an exemption, we can amend the original filing to include those additional activities.
Thank you, Jason. And I just checked with staff, and it looks like we are done with all the questions in the queue.
Okay. If we want to, we can give folks another minute or two to go ahead and get any last minute questions in before we end the webinar. And, again, we are processing things on a rolling basis based on state provisional expiration dates. We meet with the Department of Cannabis Control on a weekly basis to go through our pipeline and their pipeline. If there are comments, questions, concerns about a specific DCC record, please forward that to your analyst, and they'll escalate it to a senior manager so that it can be raised during the standing meeting with DCC. Your DCR analyst would be able to provide a link to the state clearinghouse filing. State clearinghouse is also known as CEQA or the OPR website. We use them interchangeably. If your analyst is not available, just sending the email to DCR licensing at lacity.org, and including the core record number, the applicant, and the business premises address would be sufficient for us to, find out whether or not there's an NOE filing for that particular business. Those are all public documents that are uploaded through the state website. So if we filed the NOE through OPR, we'll provide you the link. If we haven't, uploaded it through OPR, we don't have direct links to any of the county clerk filings. We get mailed stamp copies back, and then we scan them and attach them to the other documents and get them uploaded to CEQA. So we would provide a link when it's uploaded to CEQA. And then, of course, again, when your state provisional license expires, that's going to be the biggest driver on how quickly we complete our environmental analysis. And then that drives us getting it to the county clerk. That drives how quickly we get the mailed filing back and we can get it uploaded to CEQA. So, there is a long bureaucratic process tied to all of these filings, but we're moving as quickly as possible. And we anticipate incorporating the invoicing for this review, routing to the consultants to be done at the beginning of the application process so that the consultants are processing the environmental review in parallel with your DCR analysts reviewing and processing your application documents. Did we get any other questions?
We did. One from Eric D. How do we search for our NOE in CEQA?
So I do have the information up on the screen. You would go to the CEQA website, and if a member of the DCR team could drop that link into the chat if we haven't already done so, I'd appreciate it. And to narrow the fields and do the database search, you can use the end range. You can use the current date as one of the earlier questions kind of alluded to. There's a limit on the number of returns they get, so you can play around with that end date. So if you did have something going before the Cannabis Regulation Commission in October, or you had something that went in December, you would want to adjust those dates accordingly. Generally, we get stuff filed within 4 to 6 weeks of the date an action was taken by the commission or a notice of complete application for the non-retail records was issued. Document type is going to be an NOE notice of exemption. The lead public agency is going to be the city of Los Angeles. You'll click on the get results, and then based on those results, you're looking at the title, which is the title for your project, and you're looking for your 6-digit DCR core record number. And, if you're having problems finding it, or you think it's been filed and you just need the link, you can again email your DCR analyst or email DCR licensing with the core record number, your applicant name, and then the business premises address.
We do have another question from MS. In the interest of time, may an applicant help DCR staff with preparing sample docs?
It would not save DCR any time. Ultimately, once we determine that a project qualifies for a notice of exemption, as part of the final vetting process, we have a legal secretary prepping the documents that get attached with the files for the non-retail activities. And then, of course, after the Cannabis Regulation Commission adopts a recommendation to issue the annual license and adopt the environmental findings, they prepare the county clerk NOE and OPR forms for review and signature. And then the documents are there. It's just a matter of when we get stamped copies back from the county clerk.
Let's see, a question from MS. Will there be any grant funds to help pay for consultant fees?
The businesses with the provisional license the local jurisdiction assistance grant funds can be used to pay for the environmental contractors doing the environmental analysis. And DCR's admin team is assessing those fees on the record and then also waiving the fees and issuing a receipt showing the fee waivers as part of the ongoing process of issuing notices of complete application and transmitting things to the cannabis regulation for consideration. Folks that don't have a provisional state license will not be eligible for LJAG funding. And our 2024 California Equity Grant does not have capacity to absorb any consulting costs or environmental costs. We would look to see whether or not we have capacity in the 2025 grant year. But if you don't qualify for LJAG, at this time, we don't have a waiver available to you.
Okay, I think we have checked and there are no more questions. Thank you so much.
Thank you all for joining this webinar, and DCR staff will make sure that it gets uploaded to the website soon. And I look forward to hearing from everybody and doing our next webinar presentation. Thank you. Bye.